Hello, everyone. This is Roger Royce with the 10,000 Startups podcast, where each week we bring you original content of legal issues of interest to startup companies. We try to make our content very accessible and very practical for you, the startup founder, and those of you who invest in them. Today, we're going to have a special presentation. We're going to talk for the next 20 or 30 minutes about a topic that is relevant to every tech company that I do business with. As you know, I'm a lawyer. I work in emerging growth and venture capital with the law firm of Haynes Boone. I'm in downtown Palo Alto, heart of Silicon Valley. I do startups and investors. And as I said, almost all my clients are technology startups, and all of them have some valuable intellectual property that they want to protect. Today, we're going to drill down on one type of intellectual property in particular, and that is trade secret and a little bit of patent. Now, I'm not a patent lawyer. I'm not an IP lawyer. I'm a startup lawyer, but I do enough of this to know that intellectual property rights are very important, and there are things that we need to do to protect them and to strategize about them. Now, pretty much all of my clients rely pretty heavily on valuable trade secret information. And let's recap. I'm going to drill pretty deep. I'm going to double click on this. I usually spend just a few minutes on this in all of my presentations, but today I'm going to talk a little bit more about trade secret. So recall what a trade secret is, right? Three things. Okay, it's secret. First, it's information that is secret, not widely known to the public. And that could be a formula, a program, a device, a method, a technique. Usually it's a process, but it is confidential. Secondly, that secrecy gives it value. It has independent economic value by virtue of the fact that you know this process and not everybody else does. And thirdly, and this is the tough one, it's subject to reasonable efforts to maintain its secrecy. And that's where most companies mess up. They don't take those reasonable efforts to maintain secrecy. Now, this can apply to all forms and types: financial, business, scientific, technical, economic, or engineering information. It can apply to data. It can apply to customer specs. It can apply to employee specs. It applies to all kinds of different information if it meets these three requirements. Now, let's drill down a little bit on this definition before I move on to some of the more modern issues. And this is something that's always been around and will always be around. What does it take? What do you, the company, have to do to turn that secret into a valuable trade secret that the law will protect? And what do I mean when I say the law will protect? It means that you have the right to even go into court if you have to, but to sue, to prevent. You have the right to prevent somebody else from using that information. This desk that I'm sitting at, my right of ownership exists by virtue of the fact that I can keep anyone else from using this desk. That's what it means for me to own this desk. Same with a trade secret. If you look at it through the property lens of law, it is your right to keep other people from using it. That's the property right. Another way of looking at intellectual property rights generally is through the regulatory law. You're granted a bit of a monopoly on this. I'm given a monopoly over this desk. So in a way, it's sort of a regulatory issue. However you want to look at it, whichever metaphor works best for you is fine. The important thing is that we protect those rights. So reasonable efforts to maintain its secrecy. Most people, when I say that, the first thing they think of and the first thing they should think of is an NDA, non-disclosure agreement. So anybody that you let in on this secret of yours had better sign an agreement that says they are only going to use it for the intended purpose to evaluate a business relationship, to perform some work for you, and to approve upon it, whatever it is, and that they are going to keep it confidential. That's what an NDA does, essentially. There's a lot of other stuff we will put into an NDA, but at a high level, that's what we need. That's the agreement that we need. If you don't have that, and if that person is free to go out and disclose that secret to the world, you could lose your trade secret protection. So it's super important. And this comes up in a lot of contexts. One is in general business relationships. You have an investor doing a deep dive and due diligence. At some point, you may or may not get an NDA later in the process. You certainly would not ask for one too early, or you won't see that investor again. But a better example probably has to do with employees, right? Employees and contractors, for that matter, any service provider who touches your technology, they had better sign a proprietary information agreement and invention assignment, also called a confidential information agreement and invention assignment, which basically protects your rights in whatever it is that they're developing. So you'll usually find a couple different components. One is non-disclosure. They don't disclose what they find out about your trade secrets. And secondly, they assign to you whatever it is that they're doing for you. Those are really important. Additional aspects of this protection will also include some things that are not paper. They'll include some things that are much more technology or even practical or even business process oriented. For example, it's a good idea, I always say, that your trade secrets walk out the door when your employees walk out the door. So you definitely don't want to have every employee to know everything about all the aspects of your company. That's one way to protect it. You ring fence certain types of IP to different types of employees, so no one employee can walk off with your most valuable asset. Another, and maybe I don't know if it's more important, but it's certainly important, is good cybersecurity, good data security, good protection. In other words, you don't want your systems to be so lacking in protection that almost anybody can hack in or anybody can walk in and figure out what it is you're doing and how and why. Whatever it is you're trying to protect, it better not be easy to get. So that's some very basic things. I had this question come up this week. Somebody said, gee, should we be having all of our people write down on a piece of paper exactly what it is that they're doing for us so we know what's our trade secret? And the answer is yes. Yes, absolutely. That is a really good practice. Have your engineers or your coders or whoever it is make notes. Keep a notebook every day. They fill out that notebook of what they've done, right? And that way you can establish that what they've done, they did while working for you, while you were paying them on your premises, and that it belongs to you. It's your IP. And then you will protect it further with trade secret protection because they've signed an NDA and won't disclose it to anybody. Now, the question I get most often about this is, gee, should I rely on trade secret or should I get a patent? And I'm not a patent lawyer. So first of all, I believe in patents. I think you should patent early and often. I get that. However, not being a patent lawyer, I can tell you that the environment has changed and is changing. And I see less patent protection now than I used to for a lot of reasons. And the biggest one is cost. It's just very expensive to get patents. It just is. I still want you to get patents. I'm going to tell you what your litmus test is in a minute. But before I do, I want to talk a little bit about why trade secret, has some advantages over a patent. Number one is cost. The second thing is uncertainty, litigation uncertainty. Patents now are no longer what they used to be. And by used to be, I mean more than 10 years ago, before some recent cases that have challenged the validity of business process patents or business method patents. Now, good claims, of course, can deal with that issue. But because of that uncertainty, we see a lot of people doing more and more reliance on trade secret. Now, here are some other advantages of a trade secret. First of all, a patent cannot be obvious. It has to be non-obvious. But trade secret doesn't have that problem. As long as it's secret, it doesn't matter if it's obvious. If it's secret and it's valuable and you've protected it, that's not really the standard. You don't have to file anything with the government, right? So you're not telling the world what it is that you're doing. Plus, you're saving the cost of the filing and the hassle of it. The trade secret can evolve over time, unlike a patent filing. You file for your patent, and whatever your claim is, however you described it, that's what you potentially get protection for. If it changes, that invention changes, the patent may not cover the changes. With the trade secret, it can usually constantly evolving and changing and adding. So the trade secret covers that, which is why I usually see trade secret and patent work together. Trade secrets can last forever, patents cannot. All right, just ask Coca-Cola, ask Pepsi, right? Their formula, which they claim are trade secrets, are if they were protected by patent, would have expired long ago, right? But they can last as long as you can keep it secret. That's a pretty big one for some industries. My typical tech company client, 20 years is about 4 lifetimes. So we don't concern ourselves too much with that, but still, you should know about that. This is really interesting. Somebody could design around your patent. They could look at your patent and say, oh, that's how you do it. We're just going to change it and do it a little differently. We're going to design around it so we're not infringing. But a trade secret has a little broader protection. It might very well extend to improvements that derive from the trade secret. So I think it's oftentimes harder to design around. And finally, and this is a big one, and probably what really prompted me to do this presentation, is new industries, right? We've got new industries now emerging that it's not super clear that we're going to be able to get good patent protection for those industries. Let me give you a good example. The one we're all thinking about, generative AI, artificial intelligence. Now, AI is not new, of course, and machine learning is not new, but there certainly have been some new developments lately, right? We all know that. And that's giving rise to all sorts of intellectual property rights that I never really had to think about that much before. Let me kind of go through some of the intellectual property rights implicated by AI. The assets could include the formula used in the AI model, the training data, the output of the generative AI, the conversion of that output, the end products. So how are we going to protect all that? Well, actually, we could be implicating all sorts of IP provisions, patent for one, copyright for another, and especially trade secret, because the patent of this stuff, I don't think is straightforward at all. And I would say that probably most of the protection of the IP is going to be through trade secret. Now, these other types of IP protection can and may apply, but I really think most of it is going to be protected through trade secret. So continuing, I said there were some disadvantages of trade secret as relates to patents, and there's two big ones that I think I want to mention before we move on and talk more about some of the new technologies. And the big ones are that trade secrets are really easy to lose, right? It's very easy to lose that. Like I say, an employee walks out the door, your trade secret walks out the door. An inadvertent disclosure could cost you your protection. In fact, there is a case, I believe it was in Delaware, where a company during COVID did a Zoom call to put a slideshow, a PowerPoint up on the screen, and it disclosed its trade secret. And because that Zoom was open to the public, court said, look, you lost your trade secret protection. You lose, you did not take reasonable steps, even though it was inadvertent, it was disclosed, you lose. Second thing is that trade secrets can be reverse engineered, right? A patent, you don't have that problem. You're telling the world through a federal filing how you do it. That's not the issue. It's just the fact that you're first to file. That's the issue. But the trade secret, if somebody figures out how you do it themselves, if they can reverse engineer it, well, then you lose that trade secret protection. You can't really stop them because they haven't violated your NDA, they haven't stolen anything from you, etc. Now, knowing this about patents and trade secrets should give you a clue as to how you might want to approach a really good trade secret strategy. I told you how to protect it. We've gone through some of that, but should we patent it or should we trade secret it? And the answer is, for most technology and most companies that I work with, the answer is both, right? We want to patent the stuff that can be reverse engineered. We want to patent the stuff that's not going to change. It's fairly immutable. But we want to rely on trade secret for the stuff that cannot be reverse engineered. And we want to rely on trade secret for the stuff that is constantly changing and improving and updating, etc. And usually, if you can put those two components together, you've got a really good IP strategy. Now, before we leave, I just want to pause on the types of information that we're talking about, because I've been very general up till now. So I don't usually do this, but I want to drill down on this. What do we mean? What kind of information are you talking about? So here's a few categories. And I gave you some broad terms earlier: processes, design, systems, etc. So number one, products, right? If you've got designs, if you've got a hardware design, if you sell hardware, or if you've got some information specific to how you build a product, that's an example of a trade secret. Basic research, your basic research could be subject to trade secret protection. Processes and designs, we talked about that, but this could include even business processes, your manufacturing process, exactly how you do it, what step comes first, and when you add this and when you do that. That's a process. That's subject to trade secret protection. The information, the specifications, business information, that could be things like prospects. It could be market research, right? It could be competition research, competitive analysis, competitive intelligence. And this is a big one: specs for your customers, right? There's specifications. I've seen that one fought over before. Specifications for your employees, your suppliers, your vendors. All of that could be so. Corporate strategy could even be trade secret protected. And then finally, I'll just say broadly, just software. And by that, I just mean any applications, algorithms, any of that stuff could be subject to trade secret protection, as well as other types of protection. And finally, I want to double click on what are reasonable steps. Remember, I said to be a trade secret, you have to take reasonable steps to protect the information. Well, what are reasonable steps to do that? So let's just, like I say, double click on that for a minute. So number one, remember what I said about agreements. You want NDAs with everybody who touches your technology. You want CIAs, that's confidential information agreements, with every employee or third-party consultant that works on it, that basically says they're going to keep it confidential, everything that they see. And this is separate from the invention assignment that we talked about earlier. Secondly, it's a good idea to have internal training to let people know what they can and cannot do. And to do that so they understand how important it is to follow all of these processes and procedures. So what are the processes and procedures? Well, the big one is to have a written, formal trade secret policy. And that trade secret policy is going to touch on a handful of things. Number one, just guidelines and prohibitions on how data is accessed and how it's used, how it's stored, how it's shared, how media is used, how it can be checked out and checked back in, and how it's, how we can keep track of who has what, when. Electronic monitoring. How do you monitor access, right? Are you able to see who's looking at what, when, right? You should be able to have digital access and monitoring, is what I mean. And then again, just having a written policy that lays all of this out, everything and in great detail. For example, are people able to access this on their phone or their personal devices? Are people, do they have content guidelines, right? I mean, what kind of protocols and procedures are required before they can actually get access? So, and that brings me to kind of the last thing, which is security. And that's probably one of the things that maybe gets overlooked, but it's really important to a good trade secret, a really good trade secret process and policy, and part of those reasonable steps. And that would include kind of basic stuff that we all know about now, basic encryption to secure documents, 2FA, two-factor authentication to get into access to a lot of these documents. Pretty basic stuff. And file access control, system level access protocols, where we restrict access to documents. We talked about that. And retention control. So if we got a policy as to how documents are removed, how they're checked out, how they're checked back in, who has access to what when, and to keep a really good record of it. And these days, there are really good AI tools that will monitor that and will alert anybody if something is amiss. For example, if a lot of documents happen to be being downloaded at the same time. Now, I know I've hit that at a high level and I've hit that quickly, but really this is a very factual issue. So all I can do is talk in generalities, but I think it's really important that people understand the value of trade secrets to their company, how important they are to keep, and how easy they are to lose. This is Roger Royce with the 10,000 Startups Podcast. I hope to see you again next time. Thanks.